I am Regina Edwards. I am the founder of the Lawyer on the Beach Facebook group. And we're doing a webinar series with different coaches on different kind of specific either practice areas or areas of how to practice law to kind of help people who are just lurkers trying to pick up tidbits on different practice areas or how to manage their practice, or if they're thinking about hiring a coach or thinking about changing practice areas, all of that. So everything is always going to be on the YouTube channel. There is a playlist specifically for the coaching webinar series. So obviously you can refer to this recording at any time. So today I am very, very happy to have Jen Lee with me. Jen is a bankruptcy attorney, and she and I met last year when we co-presented with the ABA Tech Show on, oh my gosh, what did we present on? Communications? I think it was like client communications or something.
Automation, yeah.
Yes, automations and communications. And as we were preparing the seminar, I kind of felt like she was like my, I don't know, sister from another mother or something, because we just really kind of had a lot of symbiotic ideas about communication and being proactive and flat fees and all of that stuff. So Jen became a lawyer later in life. She was in insurance and underwriting for 10 years. Then she opened her law firm straight out of law school. And she has an MBA, so she's super smart. So she focuses on bankruptcy and debt, and also helps coach attorneys in law practice management as well. So take it away, Jen.
Thank you. And as I do that, my dog starts barking. That always works, right? So I did do a PowerPoint. I know that's very cheesy for lawyers.
I love PowerPoint. I don't know why people hate on it. Like if it ain't broke, people.
I like it because it just keeps me on track sometimes, because I can go off on tangents. I am very passionate about bankruptcy and law practice management, so I can kind of go off on tangents. So I did do a quick PowerPoint. There's my background. So as a bankruptcy attorney, it was really interesting. I filed a lot of bankruptcies for lawyers and law firms. And as I was doing that, I realized that we're not really taught how to start practices, how to do things, and how to do the business side of things. And so that's kind of how I got into this as a side gig. And now I've turned it into almost a full-time gig of helping solos and small firms. And my flagship course is building a bankruptcy practice from start to finish, because what I found out there were so many programs like Learn Chapter 7, Learn Chapter 13, all these CLEs, but no one talks about like the nuts and bolts of how do you even start? Like what software do you use? What are considerations you need to think about for fee agreements and things like that? So more practical. Some other things that I do these days, I have something called the Breakup Roadmap, because I'm running across a lot of lawyers who are not satisfied with their current firm. They may have been there a long time. They always thought maybe they would open their own practice, but they never knew how to do it. And every time they mention it to someone, everyone's like, oh, that's a bad idea. You shouldn't do that. And so I have a lot of fun helping people go solo in their 40s, 50s, and even 60s these days. And so I have a few other things I do. Let's talk about bankruptcy mostly, because that's the fun part. One thing I wanted to talk about was what the bankruptcy market looks like these days. And my course got started because back in March of 2020, when COVID hit, I was getting bombarded by phone calls from attorneys saying, I need to add bankruptcy as a practice area. This is going to be booming. This is a huge thing. Everyone's got all these financial issues. And then all the stimulus happened and all of the extensions happened.
Oh yeah,
and bankruptcy did not boom.
Handed out money like candy, just shoot.
They were. It was like this started. And so basically bankruptcy firms, my revenue dropped from the first quarter. I had the best quarter ever of 2020 that I'd ever had. Bankruptcy had been picking up, by the way. 2018, 2019 were really good years. It was starting to ramp up again, and recession was coming anyway. But then 2020, my second quarter, qualified me for every single government program out there because it dropped so fast and so quickly. So before that, in like March and April of 2020, all these people kept calling me, I need to add bankruptcy. So I launched this course in about 2 weeks, put it all together. I didn't have any clients, so I had plenty of time to work on it.
So they were all in divorce court, Jen. Because I'm telling you, I call it after the Tiger King period, because that was April when everybody was happy and wearing matching pajamas and watching Tiger King. And then shit got real in May. Everybody filed for divorce. So that's where they spent their money.
That makes sense. And so we kept holding on, thinking, okay, bankruptcy is going to pick up. It has to pick up. And I would say right now in November 2023, it is finally picking up. So we are 3.5 years into this, and it is finally, we're seeing a lot more people calling. And I will say, it's a lot of people who called back in the beginning, but bankruptcy clients have to be forced to do something. They are, and we'll talk a little bit about the bankruptcy client mindset because it's very important that you understand that before you get into bankruptcy. They have to be forced to do something, that there's no wage garnishment happening and there's no reason for them to call you. They're not going to call you until the very end. So I will say it's picking up. It depends on the area. I think California picks up first, and we're seeing that a lot in California right now is big pickups in consults and things like that. So the first question, I like to talk about fees because I think lawyers should be paid. I think lawyers should be paid well for their services. And almost everyone asks me, but aren't your clients all broke? How do you make any money at this? So there's a couple ways to make money at being a bankruptcy attorney. One is to have really good systems, good checklists, good automations done, because that's where you make your profit margin at. But your clients, yes, they're overextended and they're confused and they're overwhelmed. Their mindset is that way. If you have a personality that calms people and you're able to talk them through, or you have staff members, I have a really good business manager who does most of our client communication, and she's really good at getting people to calm down. Clients have money. They just, okay, I say they have a resource allocation problem. That's usually what my solution is for bankruptcy clients is they have money. A lot of them make way more money than a lot of attorneys do, but they just don't know where to spend it. And if you've ever been late on a credit card payment, the credit card company is going to call you the minute that you are late, calling and calling and calling and calling to get you to try to pay something. And so people get overwhelmed and they start paying those bills. And they don't pay their mortgage because their mortgage isn't calling. The mortgage doesn't care. They're secured against their house. So a lot of times explaining to the client how they can afford you is part of your initial discussion. Most clients can afford $2,000 to $10,000 for a bankruptcy attorney if you explain how to do it. But if you go in with the mindset that my clients are broke, they won't pay me, then those are the clients you'll get. So just putting that out there. On its mindset, I'm a little woo-woo that way, but I will say most of my simple chapter 7s are still, you're still making between $2,500 and $3,500 for those cases. And it's fairly straightforward. So, and then talking about profitability, and I do talk a lot about fees because bankruptcy attorneys, everyone thinks they're broke. And if you go into some of the bankruptcy attorney Facebook groups, a lot of them are lamenting how broke they are. And it's not required to be broke. You can do it efficiently and effectively. You don't have to be broke. So yes, you can be profitable. I include in my course a forecasting spreadsheet so that you can kind of figure out how many cases you need to bring in each month. And you'd be surprised. It could be as little as 2 or 3 cases a month that you would have to bring in order to make a profitable bankruptcy, depending on how much you want to make. I had a gentleman I recently helped set up his bankruptcy practice. He was transitioning from the practice area, and he was really surprised when we started looking at the numbers that were required. He's like, oh, I was thinking I had to bring in like 30 cases a month. And I'm like, if you're filing 360 cases a year, which would be 30 cases a month, you are a high volume filer, and you probably need to have multiple staff to keep up with 30 cases a month. So there's different models. You're familiar with other practice areas. We do a lot of flat fees in bankruptcy. If you're going to do corporate Chapter 11s, those are hourly, but it's really easy to forecast and do cash flow analysis because it's predictable. And that's the ones I've helped switch to bankruptcy or add bankruptcy. They're looking for like steady cash flow. They do personal injury, or they do VA benefits where it's up and down cash flow. Bankruptcy is their kind of rock steady where they just keep going with it. I threw software options in here because a lot of it is software based. Bankruptcy software there's several of them out there. I go through them in my course because I want you to see the different versions. I highly recommend cloud-based for everything. I don't have a server anymore. I haven't had a server since 2010, and I refuse to deal with a local server. But there's a lot of options out there, and they're fairly inexpensive. Most of them are like an annual subscription, like some of them you could do monthly on some. Some of them are pay per case even. So if you just wanted to get started and do 1 or 2 cases to see how it goes, you can try out software for like $40 or $60 per case.
So Jen, what are you using?
I use Next Chapter.
Oh.
And I've actually used all of them. I started out on Best Case, and then I quickly got rid of that because it was server based. It's like an MS-DOS program. That's what it looks like when you log into it. It's horrible. It's horrible. But if you talk to bankruptcy attorneys, they're like, "Oh, that's the goal." I'm like, "No." And they've been promising for 8 years to get a cloud-based version, and they haven't. So I am very outspoken about software. Jubilee is another cloud-based option that I also like as well. I go back and forth between Jubilee and Next Chapter being my favorite. So there's 2 out there that are really good. And there's one, if you're on Windows, I'm a Mac user, so I have to have cloud-based. But if you're on Windows, there's one called BK Assist that a bankruptcy attorney wrote. And so it's very intuitive for bankruptcy attorneys because he wrote it as a bankruptcy attorney, but that is a Windows-only program. So I don't use that one anymore. But there are several out there. And like I said, costs, even the maximum, like the Next Chapter WOA program, which they call it the WOA because all these templates, all these things in it, is only like $1,900 a year. So it's not crazy expensive. So if you want to be a lawyer on the beach, bankruptcy is a good practice area to be in because we've been electric filing since 2000. So that, yeah, it's all electronic filing. You can't file by paper. I mean, I guess I don't know why you'd want to, but it's all electronic filing. It's all on Pacer. You have access to the entire country bankruptcy on Pacer. You can see everything that's out there. As soon as COVID hit, they did our 341 meetings are the meetings with the trustee that are done about 30 days after filing. And those used to be in person. So when I had cases in Oakland, I would have to drive an hour into Oakland. My clients would have to drive an hour and a half or 2 hours because we were in the far east of the county. And it would take a whole day. As soon as COVID hit, they're like, "Oh, we can do these by phone." And we've been saying that for years that we could do them by phone, but it was such a hurdle. And now the entire system is going to Zoom. They're doing zoom.gov now for all 341s.
That's awesome. That's absolutely awesome.
Yeah.
I've been to a 341 meeting and I was like, this
Yeah.
can't have been an email, y'all.
Right?
Why did I go? I think I was the creditor.
Yeah.
Yeah. But I honestly was just interested in going. So I just went and we were just all sitting there looking at each other. We're not going to get any money. Why are we here?
Well, I mean, most people realize that they're not. The creditors can get a little crazy sometimes. If you have a difficult case where maybe you have, for example, a construction client who's like gypped a bunch of their clients, they took, advances on materials and things like that. I've seen some of those go a little crazy where you'll have like 20 construction clients show up for a 341. But since they're all going to video, they're fairly straightforward. In my course, I walk through how to prep a client for it. Your 341s are usually 5 minutes long that you're actually participating in because it's just verifying information. They can be longer if you have a complicated case, and then you should be charging more because you should be able to identify that up front that there's going to be some complications. But for the most part, a regular bankruptcy case is 5 minutes with a Chapter 7 trustee or 13 trustee. Even the hearings, so not just the 341s, there are court hearings in bankruptcy, especially in Chapter 13. And almost all of those have a phone or a Zoom option, unless you're getting into a trial. Like if you're going to an evidentiary trial for something, some judges are going to want you to be there in person. Sometimes you want to be there in person for depending on your client. So you can choose, though, whether to get into litigation in bankruptcy or not for the most part. Your fee agreements can say, I don't do adversary proceedings. I don't do anything that's contested. You may want to partner with someone who does, that's local if you're not in that area, so that you can hand off a case to them. We do that a lot where we're going back and forth between a couple of firms because my firm does do litigation. We have one of the partners does litigation. So malpractice pitfalls. So if you ever post in a Facebook group that you're thinking about adding bankruptcy as a practice area, you'll have like 45 bankruptcy attorneys jump in and say, oh, if that's just malpractice waiting to happen, you can't. And you'll see this a lot of practice areas. There, everyone's always trying to caution you not to enter their practice area. Yes, there always are malpractice areas, but you can learn. I learned bankruptcy. I started my own firm without any bankruptcy knowledge whatsoever and did not commit malpractice. I mean, probably by the grace of God sometimes, but there's ways to learn, and there are a lot of helpful um, attorneys out there. I help a lot of attorneys with their first couple of cases. I'm happy to help, even in my own district, because it's better to have competent attorneys than crazy things happening in bankruptcy court where you're trying to fix what other attorneys are doing. You do have to know local rules. They're very different from district to district. Everyone's like, oh, bankruptcy is federal law. Yeah, just like everything, it depends on your local courts. You're going to want to know your judges and your district and the local rules. That's no different than any other area. And then exemptions and assets are done by state. So you need to know what your state laws are for exempting assets and things like that. So that's my key there. The other thing to watch out for that new attorneys get caught up on is preferences and fraudulent transfers. All of our clients are stressed out. And I don't know how many times you have, like in family law or things, well, I can just transfer this to my daughter for $1.
Oh yeah, I'm doing a case now where he deeded over the marital home to his brother for $10 a week before he filed for divorce. I'm like, oh, yeah. You got me.
No one's ever thought of that before. You're
so clever.
So those are the things you have to watch out for, people trying to be smarter than the system, and you have to catch them before you file the case so that you can be able to kind of herd it through the system correctly or not file the case. There are sometimes when someone tells me, oh, this is what I did, I'm like, we are not filing. We do not want a bankruptcy trustee involved in this at all. Because it's just going to be a nightmare and years of litigation.
You might talk about this later, but do your clients pay you with credit cards? Because can't that be an issue?
No, so I do not take credit cards unless it's from a family member. I do recommend that you have some way of electronic payments, because I will say cash flow drastically improved when I started taking electronic payments. But we specify in all of our instructions for payment that they cannot pay us with a credit card that will be one of their own credit cards. A family member can pay for it. We take ACH through LawPay is who we take ACH through. And a lot of people will be like, well, can't I just put your fees on a credit card? I'm like, no, you can't do that.
Because we know what's going to happen with that. Can they do an e-check though?
Yep. They can do e-checks on LawPay. It's really easy. And then we put in all of our things, pay with a debit card. You can't charge things in your credit cards for like the 70 days prior to filing. All of those rules we try to run through with them. Because the other thing people try to do is like, I'm filing for bankruptcy, so I'm just gonna go run out my credit card.
Buy a bunch of shit, right?
Right. I'm gonna be at the Louis store here shortly or something like that. So we bring that up to a lot of times. And what you'll see with bankruptcy practice, a lot of it is educating clients in snippets that they can understand. Like you can't send them a 40-page document and expect them to read it, but you can do short videos, you can do things that help them through the process without overwhelming them. So tools and continuing education, bankruptcy does evolve quite a bit over the years. Like any area of the law, as new laws come out and Supreme Court cases affect bankruptcy. The National Association of Consumer Bankruptcy Attorneys is the premier consumer side organization out there. I highly recommend you join. If you're going to do any bankruptcy work, they have a great listserv, they have a great Facebook group. A lot of us we do speaking at conferences and we help out a lot of the newer attorneys, and it's a very collegial space to be in, the debtor side especially. And even working with credit attorneys, it tends to be a very collegial space. There's always exceptions. You always have that one attorney who has to be a jerk about things, but for the most part, it's a collegial space. American Bankruptcy Institute, ABI, is more creditor focused and more corporate, but I do find a lot of good information in their membership. There's lots of Facebook groups. I'm happy to share all the Facebook groups out there. And then my other tool is I did create a workshop for this, for building a bankruptcy practice. So I was just going to run through kind of quick what that looks like. There's 11 modules and there's a bunch of bonuses out there. But it really does take you through, okay, what do I need to think about when I start? What does forecasting look like? What are my first steps? How do I get the ECF access I need? So very nuts and bolts. I am a very practical person. Like, I get annoyed at law school that teaches you nothing about actually practicing law. And so I made this so that you could start at the beginning and 11 hours later, you could actually open a bankruptcy practice. That's how I created this. There is like module 7 and 8 down here on bankruptcy basics. So there is bankruptcy law in here. And those modules are double the length of the other modules because there is like actual legal analysis that we put in there. I did a whole module on the initial consult process. I charge for my consultations, and Regina knows this because every time something comes up on Lawyer on the Beach, I will chime in on, if you are a bankruptcy attorney and you're not charging for consults, you are just throwing money away. You are tire kickers will ask you, they will waste your time all day if they think you're going to give them free advice.
Oh, absolutely.
It's
and then
crazy.
I realized they'll call like just a bunch of people and say, well, this person said this, and basically try to fill all the gaps in their knowledge.
Yeah, they will. And if they can't afford, so I charge like $200 for an individual. It's $400 if they're getting divorced and we need to do some planning. I do, and I freely share my fees. They're on my website. $500 if it's a corporate, we're trying to look at a corporation and figure out what they're doing. And they're usually like 30 to 45 minutes long. And if they can't afford you to pay you $200 to $500, how are they going to hire you to be their attorney? So that's kind of where I come from. I do teach a class on charging for consults. It's a really fun workshop because I make people get out of their comfort zone a little bit on it, figure out what their value is. Because if your marketing is free consults, then your bankruptcy practice is the same as everyone else's. But there are ways to do it that be different. So these are the other modules. I do give copies of fee agreements, examples, how bankruptcy fees actually work in practice. Marketing is one of my favorite things. If you are good at explaining financial stress, bankruptcy is a key area to be in because most of your clients don't know they need a bankruptcy attorney. Most clients think, oh, I have a debt or credit problem. They don't think I need a bankruptcy attorney. So if you can avoid calling yourself a bankruptcy attorney and market to people with financial stress, there are 100 million people in this country who could use your help, honestly. And then I did go through like seminal bankruptcy cases in module 11. And then my bonus module is war stories, because I learned a lot my first few years by just sitting in court and sitting in 341s and listening to all the problems. And so I did a whole module on the things that I've learned just sitting and watching and listening through real life examples. So for Regina's group, I did do a discount. So it's a pre-Black Friday because I hate Black Friday. I hate all the emails I get for Black Friday. And so I did a pre-Black Friday. And it's 20% off the entire course through November 22nd. And the link is here. After November 22nd, it goes back to regular price. And it's $19.97 is the regular price on it. So it's like $15.27. And you get access to the full course right away. There's no like dripping it. There's no anything. You get access to the full course. There are options afterwards if you want to consult. I've reviewed cases for attorneys. Usually if I do a CLE, I do a lot of California CLEs on bankruptcy terminology. I'm doing one on Tuesday for CEB on dischargeability of certain debts. I will record those and include them as an add-on for free for my workshop subscribers. So I try to add on a lot there. And I'm happy to ask questions. Regina, if you have anything that you think I should share or anything like that, feel free. And then here's my information if you want to contact me directly.
Oh, great. So yeah, I put the link to the special deal in the chat. So this is just my own question about bankruptcy. So do you price per stage, or do you usually just price for let's just say you're doing a chapter 7.
Yeah.
Do you do the whole thing up front, or?
So chapter 7, you have to get paid all of your fees up front, because if you have any fees that are owed when you file, you're a creditor.
Okay.
And so then your fee would be discharged. There are some states who have tried to do these bifurcated fees where you get paid some beforehand and then you have a separate fee agreement that you file afterwards. So you do want to check with your local whether people are doing that. I don't recommend it because if they don't sign that fee agreement afterwards, they're not required to sign the second fee agreement. You still have to represent them. They're still on the hook. So I have kind of a love-hate relationship with that whole idea. I understand getting people help. But yes, you're paid up front. Most attorneys will do payment plans for flat, and it's flat fee. Your consult fee, if you charge one, usually gets rolled into your flat fee because you have to disclose under Rule 2016 what your fees were of all fees that were paid in the case. So I just increased all my fees to include the consult fee as well. I still get paid for the consult, but and then my fees are not uniform as far as like everybody gets charged. There are some out there that do like, I'm going to charge $1,000 for every bankruptcy case. Mine are very widely. Depends on the situation, depends on how complicated, if they're a business, if they had a business. I will say that the SBA is very, very audit happy with EIDL, people who took EIDL and PPP. So if they had a business or they said they had a business and got those funds, which it seems like a lot of people were, they're going to want to know what happened to those funds.
Everybody lied. I was shocked at how many people lied until I started, when we were doing divorces in, early 21, 22, we'd always get these questions in discovery, like, what about this business? And my client's like, I don't have a business. It's like, okay, well, the other attorney went online and you got $50,000. And everyone just said the same thing. Oh, this guy just handed me some paper and I signed it and I got $50,000. I was like, oh, okay, that's clearly not a problem then.
And so that should be in your initial consult. You should ask about all the stimulus type stuff because some attorneys have been caught a little off guard when the SBA shows up at their meeting of creditors and says, well, you said you had a business and you didn't disclose that on your schedules and it's not there. And so they've had their discharge denied for all debts, not just the SBA loan, all debt discharge denied because they lied. So yeah. But yes, chapter 13 is a little bit different. Some fees are up front and then some fees are usually paid through the chapter 13 plan, the reorganization plan. So, but I always tell people get money up front no matter what for chapter 13. Some attorneys will do no money down chapter 13s, and then you are basically putting your livelihood in the hands of someone who couldn't pay their bills to start with.
Yeah, that's not a good
It's like a
business model. Okay, does anyone have any questions? Okay, so I'm going to, when I upload the video, I'll include Jen's email and her website so you can contact her there, but all the information will be in the description of the video. So thank you so much, Jen, for your presentation, and everyone have a good weekend.
Sounds good, thank you.
All right, bye-bye.